Welcome back to our series on estate planning. Today, we're going to discuss funeral trusts and Medicaid and how they can be used for effective asset management. First, let's define what funeral trusts are. A funeral trust is a legal arrangement where you set aside funds specifically to cover your funeral and burial expenses. These trusts can be either revocable or irrevocable. Revocable trusts can be altered or canceled by the grantor at any time, while irrevocable trusts cannot be changed once they are established. So, how do funeral trusts work? When you set up a funeral trust, you deposit money into the trust, which is then used to pay for your funeral expenses when the time comes. Typical costs covered by funeral trusts include burial plots, caskets, funeral services, and other related expenses. Understanding Medicaid eligibility is essential for proper asset management. Medicaid has strict asset limits that you must meet to qualify for benefits. This means you may need to spend down your assets to become eligible. Properly managing your assets can help you qualify for Medicaid without depleting all your resources. This is where funeral trusts come into play. Funeral trusts can help protect your assets and ensure you qualify for Medicaid. When you set up an irrevocable funeral trust, the funds placed in the trust are not counted as assets when determining Medicaid eligibility. This means you can set aside money for your funeral expenses without affecting your eligibility for Medicaid. There are several benefits to using funeral trusts for asset management. First, they ensure that funds are available to cover your funeral expenses, relieving your family of the financial burden. Second, by setting up a funeral trust, you can reduce the amount of countable assets, helping you qualify for Medicaid. This allows you to protect your savings and still receive the care you need. Setting up a funeral trust involves a few key steps. First, you'll need to consult with a qualified attorney or financial advisor who specializes in estate planning and Medicaid. They can help you determine whether a revocable or irrevocable trust is best for your situation. Once you've decided on the type of trust, you'll need to complete the necessary paperwork and fund the trust with the appropriate amount of money. Common questions and concerns about funeral trusts often involve the differences between revocable and irrevocable trusts, the amount of money that can be placed in the trust, and how the funds will be used. It's important to work with a professional to address these questions and ensure your trust is set up correctly. Let's look at a real-life example. Imagine someone who has significant savings and is concerned about qualifying for Medicaid. By setting up an irrevocable funeral trust, they can set aside a portion of their savings for funeral expenses, reducing their countable assets and helping them qualify for Medicaid. This not only ensures their funeral expenses are covered, but also allows them to receive the care they need without depleting all their resources. In summary, funeral trusts are a valuable tool for asset management and Medicaid planning. They provide a way to set aside funds for funeral expenses, protect assets, and help you qualify for Medicaid. By incorporating funeral trusts into your estate plan, you can ensure your financial future is secure and your loved ones are taken care of. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney or financial advisor. See you in the next video.
In this video, we'll talk about what is Medicaid planning and why is it important. Medicaid planning is an essential aspect of estate planning, ensuring that individuals can receive the long-term care they need without exhausting their financial resources. With the help of an experienced attorney, you can navigate the complex regulations surrounding Medicaid eligibility and develop a strategy that protects your assets while securing your future care needs. Understanding Medicaid planning. Medicaid planning involves analyzing an individual's financial situation and employing strategies to qualify for Medicaid benefits while preserving their assets. It is crucial because the cost of long-term care can quickly deplete an individual's life savings. You may wonder, what are Medicaid eligibility requirements? Applicants must meet specific income and asset limits. These limits vary based on factors like age, disability status, and household size. An experienced attorney can help you understand these requirements and determine the best approach to qualify. Here are some strategies for Medicaid planning. There are several strategies available for effective Medicaid planning. Some of these include asset transfers. Transferring assets to family members or into trusts can help you meet Medicaid's financial eligibility requirements. However, it is essential to execute these transfers strategically to avoid penalties. Here's how irrevocable trusts can help. Irrevocable trusts can protect your assets from being counted toward Medicaid eligibility. By placing assets in an irrevocable trust, you effectively relinquish control over them, ensuring they are not considered when determining eligibility. This is how annuities can help. Instead of annuities, converting assets into an income stream through annuities can help meet Medicaid's financial requirements. An experienced attorney can help you determine if an annuity is appropriate for your situation. The importance of Medicaid planning. Medicaid planning is crucial for several reasons, such as protecting assets. Proper planning ensures that your assets are protected from the high cost of long-term care, allowing you to pass on your legacy to your loved ones. Medicaid planning also provides access to quality care. Qualifying for Medicaid benefits guarantees access to quality long-term care services when you need them, without the burden of high out-of-pocket costs. Also provides peace of mind. Knowing you have a plan in place for your long-term care needs provides peace of mind for you and your family. Now we will talk about the role of an attorney in Medicaid planning. An experienced attorney plays a critical role in Medicaid planning, offering the following benefits. Experienced guidance. An attorney can help you navigate the complex rules and regulations surrounding Medicaid, ensuring you understand your options and make informed decisions. Customized strategies. Every individual's situation is unique. An attorney can develop a personalized plan that meets your specific needs and goals. Ongoing support. As your situation evolves, an attorney can help you adjust your Medicaid planning strategy to ensure continued eligibility and asset protection. In conclusion, Medicaid planning is an indispensable component of estate planning that aims to secure quality long-term care without jeopardizing your financial well-being. With the guidance of Heritage Law Office, you'll have an experienced attorney to navigate the complex regulations and eligibility requirements. Whether it's through asset transfers, the establishment of irrevocable trusts, or annuities, our tailored strategies offer asset protection, quality care, and peace of mind for you and your loved ones. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the Special Needs Trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a Special Needs Trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. Improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. In this video, we will discuss how to set up a land trust, its benefits, and how it can protect your assets. What is a land trust? A land trust is a legal entity that allows you to manage and control real estate assets while keeping your ownership private. This can be particularly useful for safeguarding your assets from creditors, lawsuits, and other potential risks. With a land trust, you create a private agreement where a trustee holds the title to a property for the benefit of one or more beneficiaries. The main advantage of a land trust is that it allows the beneficiaries to retain control over the property while keeping their identities confidential. Key features of a land trust include privacy, control, and flexibility. The names of the beneficiaries are not disclosed in public records. Beneficiaries maintain control over the property, and they can transfer their interest in the trust without public record changes. What are the benefits of land trusts? People often choose a land trust is the privacy it offers. Since the trustee holds the title, the names of the beneficiaries are not listed in public records, making it difficult for potential litigants to identify the true owners. Additionally, by placing property in a land trust, it becomes more challenging for creditors to seize your assets. Creditors may find it difficult to discover the existence of the trust or determine the property's value, deterring legal actions and settlement negotiations. Land trusts also simplify the process of transferring property ownership. Beneficiaries can transfer their interest in the trust without triggering a public record, useful for estate planning and avoiding probate. How does a land trust work? To establish a land trust, you need to create a trust agreement that outlines the terms and conditions. This document identifies the trustee, beneficiaries, and the powers and responsibilities of each party. An experienced attorney should draft the trust agreement to ensure compliance with state laws. The trustee holds the legal title to the property and manages it according to the trust agreement, while beneficiaries retain control and direct the trustee on property management actions. While land trusts offer numerous benefits, they also have potential drawbacks. They provide limited asset protection compared to other entities like LLCs or irrevocable trusts. Setting up and maintaining a land trust can be complex and may require ongoing legal assistance. Additionally, there may be tax implications, so consulting a tax professional is essential. Integrating land trusts with other strategies. To maximize asset protection, consider integrating land trusts with other legal entities like LLCs, which combine privacy with liability protection. Irrevocable trusts and Medicaid asset protection trusts can also enhance asset protection. Common uses of land trust. Land trusts are popular among real estate investors for anonymous purchases, streamlined transactions, and avoiding due-on-sale clauses. They are also valuable for estate planning, asset management for high-net-worth individuals, and charitable giving. To create a land trust, consult with an experienced attorney, select a reliable trustee, draft the trust agreement, transfer the property title, and maintain the trust. Thank you for watching the video. If you found it helpful, please like and subscribe.
I'm healthy, I eat kale, so I don't need estate planning, right? Wrong. You need a power of attorney. Yesterday. If you get in an accident or end up in the hospital and can't speak for yourself, no one can legally help you. Not your partner, not your mom, not your best friend. Without a power of attorney, they might not even be allowed to talk to your doctor. Imagine this. You're unconscious, your bills are due, your pet needs food, your life is on hold. But with a power of attorney, your person can pay your bills, talk to your doctors, and keep things moving. Without it, they might have to go to court just to help you. And that takes time, money, and a whole lot of stress. So listen, you don't need to be old. You need to be prepared. Power of attorney. Get it, sign it, store it, because adulting means protecting your future.
Welcome to our series on starting a business. Today, we're going to discuss the key legal steps you need to take when starting a new business. Understanding these legal considerations is crucial for ensuring your business operates smoothly and is set up for success. First, let's talk about choosing the right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure has different implications for liability, taxes, and management. A sole proprietorship is the simplest form but doesn't provide personal liability protection. An LLC offers liability protection and flexible tax options, making it a popular choice for small businesses. Corporations provide the most liability protection but come with more regulatory requirements. Next, you need to register your business. This involves choosing and registering your business name, often called a DBA, or doing business as. You'll need to file the necessary paperwork with your state and local authorities. Obtaining the necessary licenses and permits is another key step. The requirements vary depending on your business type and location. For example, a restaurant may need health permits, while a construction company may need specific contractor licenses. Research the licenses and permits required for your business and apply for them before you start operating. Understanding your tax obligations is essential. Start by obtaining an Employer Identification Number, or EIN, from the IRS. This number is used for tax filings and other business activities. You should also understand your obligations for sales tax, payroll tax, and income tax. Consulting with a tax advisor can help ensure you meet all your tax responsibilities. Creating a business plan is both a strategic tool and a legal consideration. A comprehensive business plan includes an executive summary, market analysis, and financial projections. It helps guide your business decisions and can be crucial for securing financing. Setting up your business finances is important. Open a business bank account to keep your personal and business finances separate. Set up accounting and bookkeeping systems to track your income and expenses accurately. Understanding your business insurance options is also important. Insurance can protect your business from various risks, such as liability claims and property damage. Employment law considerations are crucial if you plan to hire employees. Understand the difference between hiring employees and independent contractors. Comply with employment laws regarding wages, benefits, and workplace safety. Creating employment contracts and an employee handbook can help outline expectations and legal requirements. Protecting your intellectual property is vital. This includes trademarks, copyrights, and patents. Register your intellectual property to prevent others from using your brand or products without permission. Drafting key contracts and agreements is essential for legally binding business relationships. This includes partnership agreements, client contracts, and supplier agreements. Having clear, written agreements helps prevent disputes and outlines each party's responsibilities. Compliance with industry regulations is critical. Each industry has specific regulations that businesses must follow. Ensure you understand and comply with these regulations to avoid legal issues. Seeking professional advice is highly recommended. Consulting with legal, financial, and business advisors can help ensure you're taking the right steps. In conclusion, starting a business involves several key legal steps: choosing the right business structure, registering your business, obtaining necessary licenses, understanding tax obligations, creating a business plan, setting up finances, complying with employment laws, protecting intellectual property, drafting key contracts, and ensuring industry compliance. Taking these steps will help you build a solid legal foundation for your business. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you.
Can you sell a house that is in trust? If you own property and are thinking about establishing a trust to safeguard your assets, many people ask, can you sell a house that is in a trust? The answer is generally yes, although the process can be intricate. requiring a thorough understanding of the various steps involved. In this guide, we'll walk you through the basics of selling a house that is in trust, including what a trust is, how it affects the sale of your property, and what steps you need to take to sell your home successfully. We'll also offer some tips on how to ensure your sale goes smoothly and efficiently, so you can get the best possible outcome for your situation. What is a trust? First, let's define what a trust is. A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, who will manage those assets on behalf of the beneficiaries you name in the trust. The trustee has a legal duty to manage the assets in the trust in accordance with your wishes, as outlined in the trust document. There are different types of trusts, but the most common is the revocable living trust. With this type of trust, you can transfer ownership of your assets to the trust during your lifetime and retain control over them as the trustee. You can also name yourself as the beneficiary, so you can continue to use and enjoy your assets as you did before they were placed in the trust. The trust becomes irrevocable after your death, at which point the assets are managed by the successor trustee you named in the trust document. An important question to ask is, how does a trust affect the sale of a house? If you've transferred ownership of your house to a trust, the trust now owns the property, not you personally. This means that you can't sell the house yourself. The trustee must handle the sale on behalf of the trust. However, as the grantor, creator of the trust, you can give the trustee the power to sell the property by including specific provisions in the trust document. For example, you can include language that allows the trustee to sell the property at any time or only under certain conditions, such as when the beneficiaries agree to the sale. It's important to note that the trustee has a legal duty to act in the best interests of the beneficiaries when managing the assets in the trust. This includes the sale of the house. The trustee must make decisions that are in the best interests of the beneficiaries, such as selling the property for the highest possible price or using the proceeds of the sale to benefit the beneficiaries in another way. Here are the steps to selling a house that is in trust. Now that you understand the basics of how a trust affects the sale of a house, let's walk through the steps involved in selling a house that is in trust. Step 1. Determine the trustee's powers. The first step is to review the trust document to determine the trustee's powers regarding the sale of the property. If the trust document grants the trustee the power to sell the property, the trustee can begin the process of listing the property for sale. Step 2. Choose a real estate agent. The trustee should choose a reputable real estate agent who has experience selling properties that are in trust. The agent should have a deep understanding of the legal and financial aspects of selling a trust property, as well as the ability to work collaboratively with the trustee and beneficiaries. Step 3. Prepare the property for sale. Before listing the property, the trustee should prepare it for sale. This may involve making necessary repairs and improvements, staging the property, and setting a fair market price based on comparable properties in the area. Step 4. List the property for sale. Once the property is prepared, the trustee can list it for sale with the chosen real estate agent. The listing should include all necessary information about the property, including any disclosures required by law. Step 5. Accept an offer and negotiate. When a potential buyer makes an offer on the property, the trustee should review it and consult with the beneficiaries before accepting or rejecting it. If the offer is accepted, the trustee should negotiate the terms of the sale, including the price, closing date, and any contingencies. Step 6. Transfer ownership of the property. Once the terms of the sale have been agreed upon, the trustee should work with the real estate agent and the buyer's attorney to transfer ownership of the property. This may involve completing necessary paperwork and providing documentation related to the trust and the sale of the property. Step 7. Distribute proceeds to beneficiaries. After the sale is complete and any outstanding debts and expenses related to the property have been paid, The trustee should distribute the proceeds from the sale to the beneficiaries in accordance with the terms of the trust. Selling a house that is in trust can be a complex process, but by following these steps and working with experienced professionals, it can be a smooth and successful transaction. Thank you for tuning in, and if you have any further questions or need legal advice, feel free to reach out to us at Heritage Law Office. If you found this video helpful, don't forget to like, share, and subscribe for more informative content. Have you ever wondered what happens to someone's assets after they pass away? Today, we'll explore the world of probate, breaking it down into steps, as well as looking into the various types that are most appropriate depending on your circumstances. Dealing with assets after a loved one's passing is never easy, but understanding the process can help. Let's break down probate. What is probate? Probate is the formal legal procedure after someone's death, which settles their financial and legal affairs. It is the process that ensures assets are transferred rightly and legally to beneficiaries, and any outstanding debts are settled. But who ensures this process runs smoothly? The crucial role of the executor, that would be the executor, also known as the personal representative. They initiate the probate process, manage assets, settle debts, and ensure the rightful distribution of assets. It's a significant role, oftentimes demanding guidance from experienced probate attorneys. But how do you get started with probate? Let's walk through it step by step. Step 1. Initiating the probate process. Everything begins with appointing a personal representative, either named in the will or chosen by the court. They file a petition for probate, and here, professional legal guidance can be invaluable. Step 2. Inventorying the estate. The representative then takes stock of the deceased's assets, everything from real estate to bank accounts. Step 3. Settling debts and taxes. Before beneficiaries get anything, all debts and taxes must be settled using the estate's assets. Step 4. Distribution. Finally, the remaining assets are distributed according to the will or state laws if there's no will in place. Probate isn't one size fits all. There are different types for varying circumstances. Types of probate. Formal probate. This structured, judge-overseen process is ideal for complex estates or when beneficiaries have disputes. Informal probate. A simpler, quicker process fit for straightforward estates with a valid will and no disputes. Special administration. This method is for when immediate action is required or when full estate administration isn't necessary. Probate may seem complex, but with experienced guidance, you can be sure your estate is managed properly. Be sure to check out additional articles on probate or inquire about a consultation on the Heritage Law Office website in the description below. Also, don't forget to subscribe to the channel for more helpful legal content, and please hit that like button. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children or anyone else while you're alive. You can live in it or rent it out during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible.
In our last video, we discussed funeral trusts and how they can help you plan for future expenses. Today, we're diving deeper into how funeral trusts can play a critical role in managing your assets when it comes to nursing home care and Medicaid eligibility. As people age, the need for long-term care becomes more likely, and nursing home costs can be incredibly high. Medicaid is a state and federal program that can help cover these costs, but qualifying for Medicaid requires meeting strict asset limits. This is where a funeral trust can be a valuable tool. When applying for Medicaid, one must undergo a financial review process known as a spend down. Essentially, you need to spend down your assets to qualify for Medicaid benefits. However, certain assets are exempt from this process, including funds placed in an irrevocable funeral trust. Here's how it works. Firstly, by setting up an irrevocable funeral trust, you allocate funds specifically for your funeral and burial expenses. This means that the money in the trust cannot be used for anything else, and importantly, it is not counted as an asset when determining your Medicaid eligibility. Secondly, this allows you to legally spend down your assets to meet Medicaid's requirements without losing all your resources. For example, if you have savings that exceed the Medicaid asset limit, placing some of that money into an irrevocable funeral trust reduces your countable assets, bringing you closer to eligibility. Thirdly, using a funeral trust in your Medicaid planning ensures that your funeral expenses are taken care of without placing the financial burden on your loved ones. This is particularly important because Medicaid does not cover funeral costs, and without proper planning, your family may struggle to cover these expenses. Now, here are a few key points to keep in mind. Number 1. Make sure the funeral trust is irrevocable. Only irrevocable funeral trusts are excluded from Medicaid's asset calculations. Revocable trusts do not provide the same benefit because you can access the funds, so they are considered countable assets. Number 2. Each state has different regulations regarding the maximum amount you can place in a funeral trust and other specific requirements. It's crucial to work with a qualified attorney who understands your state's Medicaid rules to ensure your trust is set up correctly. Number 3. Medicaid's asset limits can be very low. In many states, a single individual can only have around $2,000 in countable assets to qualify. This makes it even more important to use tools like funeral trusts to manage your assets effectively. While setting up a funeral trust can be a strategic part of your Medicaid planning, it should be part of a broader estate planning strategy. Consulting with an attorney who has experience in elder law and Medicaid planning can provide comprehensive guidance tailored to your specific situation. In summary, funeral trusts can be a valuable tool in managing your assets, especially when planning for nursing home care and Medicaid eligibility. They help protect your savings, ensure your final wishes are honored, and relieve your family from the financial burden of funeral expenses. Thank you for watching. If you have more questions or need personalized advice on funeral trusts and Medicaid planning, consult with a qualified attorney to explore your options. Welcome back to our series on estate planning for business owners. In our previous videos, we've covered the basics of business succession planning and how to create a robust succession plan. Today, we're going to explore how trusts can be used in business succession planning to ensure a smooth transition and protect your business assets. Trusts are powerful tools that can provide numerous benefits in business succession planning, including asset protection, tax efficiency, and control over how your business is transferred. Let's look at the different types of trusts and how they can be used in your succession plan. First, let's talk about revocable living trusts. A revocable living trust allows you to transfer ownership of your business and other assets into the trust while you're still alive. You can maintain control over these assets and make changes to the trust as needed. Upon your death or incapacity, the trust becomes irrevocable, and the successor trustee you've appointed can manage and distribute the assets according to your wishes, ensuring a seamless transition. Next, we have irrevocable trusts. Unlike revocable trusts, irrevocable trusts cannot be changed or revoked once they are established. These trusts can be beneficial for protecting your business assets from creditors and reducing estate taxes. By transferring ownership of your business to an irrevocable trust, you remove these assets from your taxable estate, which can provide significant tax savings for your heirs. One specific type of irrevocable trust that is particularly useful in business succession planning is the Irrevocable Life Insurance Trust, or ILIT. An ILIT holds a life insurance policy on the business owner. When the owner passes away, the life insurance proceeds go into the trust, providing liquidity to pay estate taxes or buy out a deceased owner's interest in the business. This ensures that the business can continue to operate smoothly without financial strain. Another important trust is the Grantor Retained Annuity Trust, or GRAT. A GRAT allows you to transfer business assets to a trust while retaining the right to receive an annuity payment for a specified term. After this term, the remaining assets in the trust are transferred to the beneficiaries, typically your heirs. This strategy can help minimize gift and estate taxes, making it an efficient way to pass on your business. Family limited partnerships, or FLPs, are also often used in conjunction with trusts. In an FLP, you can transfer business assets into a partnership structure, which is then owned by a trust. This can provide additional asset protection and facilitate the gradual transfer of business interests to your heirs while retaining some control over the business operations. Using trusts in business succession planning offers several advantages. Trusts can help avoid probate, ensuring a faster and more private transfer of your business. They can provide continuity of management by appointing a trustee to oversee the business until your successor is ready to take over. Trusts can also protect your business assets from creditors, lawsuits, and potential family disputes. However, setting up trusts can be complex and requires careful planning. It's crucial to work with a qualified attorney who has experience in both estate planning and business succession planning. They can help you choose the right type of trust for your situation and ensure it is structured properly to meet your goals. In summary, trusts are valuable tools in business succession planning. They offer benefits such as asset protection, tax efficiency, and control over the transfer of your business. By incorporating trusts into your succession plan, you can ensure a smooth transition, protect your business's value, and achieve your long-term goals. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video. The role of life insurance in succession planning. Welcome back to our series on estate planning for business owners. In our previous videos, we've explored various aspects of business succession planning. Today, we're going to focus on the role of life insurance in succession planning and how it can be a valuable tool in ensuring the smooth transition of your business. Role in business succession planning by providing the necessary funds to address financial needs that arise upon the death of a business owner. Let's look at some specific ways life insurance can be used in your succession plan. First, let's talk about buy-sell agreements. A buy-sell agreement is a legally binding contract that outlines how a partner's share of the business will be handled if they pass away, become disabled, or decide to leave the business. Life insurance can be used to fund these agreements. For example, if you and your business partners each take out a life insurance policy on each other, the proceeds from the policy can be used to buy out the deceased partner's share of the business. This ensures that the business remains in the hands of the surviving owners and provides financial support to the deceased partner's family. Second, life insurance can provide liquidity to pay estate taxes. For many business owners, a significant portion of their wealth is tied up in the business. When they pass away, their heirs may face substantial estate taxes. If there aren't enough liquid assets to cover these taxes, the business might have to be sold or liquidated to pay the tax bill. Life insurance proceeds can provide the necessary funds to pay estate taxes, allowing the business to continue operating without disruption. Third, life insurance can be used to equalize inheritances. If you have multiple heirs, but not all of them are involved in the business, life insurance can help ensure that each heir receives a fair share of your estate. For example, you can leave the business to the heirs who are involved in its operations and use life insurance proceeds to provide an equivalent value to the heirs who are not involved. This can help prevent conflicts and ensure that all your heirs are treated fairly. Another important use of life insurance is in key person insurance. Key person insurance is a policy taken out by a business on the life of an essential employee, such as an owner or top executive. The business is the beneficiary of the policy, and the proceeds can be used to cover the financial loss that occurs when a key person dies. This can include costs related to finding and training a replacement, lost revenue, and reassuring creditors and customers that the business will continue to operate smoothly. When considering life insurance for succession planning, there are several types of policies to choose from. Term life insurance provides coverage for a specific period, making it a cost-effective option for temporary needs. Whole life insurance, on the other hand, provides permanent coverage and builds cash value over time, which can be used for other financial needs. Universal life insurance offers flexibility in premium payments and death benefits, allowing you to adjust the policy as your needs change. It's essential to work with a qualified insurance advisor and estate planning attorney to determine the best type and amount of life insurance for your situation. They can help you understand the options available and ensure that the policies align with your overall succession plan. In summary, life insurance is a versatile and valuable tool in business succession planning. It can provide the funds needed to buy out a deceased partner's share, pay estate taxes, equalize inheritances, and cover the financial loss of a key person. By incorporating life insurance into your succession plan, you can ensure the continuity and stability of your business for the future. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you.
Join us as we take on the challenge of organizing the essential documents needed for a comprehensive estate plan and learn how to avoid costly mistakes along the way. Estate planning is often viewed as a complex and daunting task, but having a comprehensive plan in place can provide peace of mind and financial security for you and your loved ones. If you don't have a proper estate plan in place, your family may be left to deal with the fallout, which can lead to lengthy and costly probate battles, family disputes, and even financial devastation. Without a clear plan, your assets may not be distributed according to your wishes, and your loved ones may be left with a huge mess to sort out. In addition, if you become incapacitated, your family may have to go to court to get a conservatorship, which can be a lengthy and expensive process. Furthermore, your medical wishes may not be respected, and your family may have to make difficult decisions on your behalf without knowing what you would have wanted. Moreover, without a comprehensive estate plan, your business and personal assets may not be protected, leaving them vulnerable to creditors, lawsuits, and other risks. In the worst-case scenario, not having a proper estate plan can lead to family feuds, lawsuits, and even financial ruin. It's a heavy burden to place on your loved ones, and it's one that can be easily avoided with a little planning and foresight. A comprehensive estate plan consists of several essential documents that work together to protect your assets and ensure your wishes are carried out. These documents include wills, trusts, powers of attorney, and healthcare directives. Each document plays a vital role in ensuring that your assets are distributed according to your wishes, your loved ones are protected, and your medical wishes are respected. A will is a legal document that outlines how you want your assets to be distributed after you pass away. It's a crucial document that ensures your wishes are carried out, and it can also appoint guardians for minor children. Trusts, on the other hand, are legal arrangements that allow you to transfer assets to beneficiaries while minimizing taxes and avoiding probate. Powers of attorney give someone the authority to make financial and medical decisions on your behalf if you become incapacitated. Healthcare directives, also known as living wills, outline your medical wishes if you're unable to communicate them yourself. Each of these documents is essential to a comprehensive estate plan, and they work together to provide a complete picture of your wishes and intentions. By having all of these documents in place, you can ensure that your loved ones are protected, your assets are distributed according to your wishes, and your medical wishes are respected. It's a vital step in planning for the future and avoiding costly mistakes. By having a comprehensive estate plan in place, you can rest easy knowing that your loved ones will be protected and your wishes will be carried out. If you don't already have a comprehensive estate plan in place, we encourage you to take the first step and schedule a consultation with an estate planning attorney today. It's a small step that can provide huge peace of mind and financial security for you and your loved ones.
In this video, we'll discuss how to protect your digital assets in your estate plan. With the increasing importance of digital assets, Ensuring they are included in your estate planning is crucial. Digital assets are any electronic records that you own or control. These can include online banking accounts, social media profiles, email accounts, digital photos, cryptocurrencies, online businesses, and subscription services. Online banking accounts, social media profiles, email accounts, digital photos, cryptocurrencies, online businesses, subscription services. Why include digital assets in your estate plan? Including digital assets in your estate plan is essential to avoid several issues. Without proper authorization, your executors or loved ones may struggle to access or manage your digital accounts. This can lead to financial loss, especially with assets like cryptocurrencies or online business revenues. Additionally, unmonitored digital accounts can be vulnerable to identity theft. Lastly, sentimental items such as digital photos and videos can be lost forever without proper access. Here are the steps to protect your digital assets. First, create a comprehensive inventory of all your digital assets. Include account names, URLs, usernames, passwords, and backup codes. Next, understand the terms of service for each digital account. Different platforms have varying policies regarding access to accounts after the owner's death. Designate a digital executor. This person will manage your digital assets according to your wishes. Ensure they are tech-savvy and trustworthy. Include specific instructions for your digital assets in your will or trust documents. Ensure your financial power of attorney includes provisions for managing digital assets if you become incapacitated. Utilize online tools like Google's Inactive Account Manager and Facebook's Legacy Contact to manage access to your accounts. Secure your digital asset inventory using encrypted digital storage or physical copies in a safe. Regularly update your inventory and estate planning documents to reflect new accounts, changed passwords, or updated policies. Inventory your digital assets. Understand terms of service. Designate a digital executor. Include provisions in your estate plan. Utilize online tools, secure storage and backup. Regular updates. Digital assets pose unique legal challenges, especially about privacy laws and terms of service agreements. Work with a knowledgeable attorney to navigate these complexities. They can help draft clear instructions, ensure compliance with relevant laws, and avoid potential legal pitfalls. To protect your digital assets, it's essential to include them in your estate plan. By following these steps, you can ensure your digital legacy is preserved and accessible to your loved ones. Take action today to secure your digital assets and ensure peace of mind for the future. In this video, we will discuss how to manage inherited property during probate, covering essential steps and common challenges you may face. Welcome to our channel. If you're dealing with the complexities of probate and inherited property, this video is for you. Let's dive into the key aspects of managing inherited property during probate. First, let's understand the probate process. Probate is the legal procedure of administering a deceased person's estate, ensuring debts are paid, and distributing the remaining assets to the rightful heirs. When handling inherited property, you'll need to locate and review the will, inventory the estate, notify creditors, settle debts, maintain the property, and decide on its future. One of the common challenges in handling inherited property is emotional attachment. Family disagreements can arise when heirs have differing opinions on what to do with the property. Sentimental value can also complicate decisions about selling or renting the property. Additionally, financial considerations like the costs of maintaining the property and potential tax implications need to be addressed. Legal complications, such as dealing with multiple heirs or unresolved debts, can also present challenges. If you decide to sell the inherited property, there are several steps to follow. First, prepare the property for sale by making necessary repairs and upgrades, and ensure it is clean and staged. Hiring a real estate agent experienced in estate sales is crucial, They can help you list the property, conduct a market analysis, and market it effectively to attract buyers. Finally, navigate the sale process by evaluating offers, negotiating terms, and finalizing the sale with the help of your agent and attorney. Here are some practical tips for handling inherited property efficiently. Stay organized by keeping meticulous records of all transactions and communications. Use digital tools and software to track important documents and deadlines. Seek professional advice from estate attorneys and financial advisors to navigate legal complexities and plan for tax implications. Communicate effectively with family members through regular meetings and open discussions. Lastly, be patient and compassionate, recognizing the emotional impact of losing a loved one and providing support to each other. In summary, managing inherited property during probate involves understanding the probate process, addressing common challenges, and following practical tips to navigate the complexities. If you need assistance, our knowledgeable attorneys are here to support you every step of the way. Contact us to ensure the probate process is as smooth as possible. Thank you for watching. If you found this video helpful, please like, share, and subscribe to our channel for more informative content. Probate is the process of administering the estate of the person who passed by gathering their assets, paying their liabilities, and distributing the remaining assets to the beneficiaries. You may ask, why should I avoid probate? The answer is simple: time and money. The probate process can be cumbersome and take significant time and money. However, the probate process can be avoided. Trusts, when properly set up and funded, can avoid probate. The question is, does a will avoid probate? No. Assets controlled by a will do not avoid probate. A will by its nature directs the assets through the probate process for administration and ultimate distribution to the beneficiaries. There are a number of ways to avoid probate. First, you can give away all your money and assets, so you have nothing to pass along. Second, you can add a joint owner to your assets or add a payable or transfer on death designee to your accounts. Third, you can establish a life estate on your property. Finally, you can avoid probate with a trust. Adding a joint owner or adding a payable or transfer on death designee is a simple solution. However, they do not offer the same benefits as a trust. Adding a joint owner or adding a payable on death or transfer on death designee does not offer asset protection for beneficiaries, can potentially cause a loss of government benefits for a beneficiary with a disability or special needs, and does not help with potential future incapacity. With a life estate, you do not own entire interest in the property. The interest in the property is split into two pieces: the current interest and the interest the other owner, the remainderman, has after your passing. Additionally, if you wish to sell the property, you can only sell the portion you own, your life estate, and you would need permission from the remainderman to sell the entire interest. A properly set up and funded trust can solve these issues. A trust can give possible asset protection for beneficiaries. With a trust, you can retain control of assets. A trust has the ability to protect beneficiaries with disabilities or special needs. Finally, a trust can plan for incapacity. The only downside of a trust is the initial setup. To ensure your will or trust is set up properly, contact Heritage Law Office today.
You just spent your whole life building everything, and you're gonna let the government decide who gets it. That dream house, your savings, grandpa's watch, your dog. Without a will or a trust, the court picks, not you. And guess what? It can take months, even years. Family fights, legal fees, chaos. But here's the wild part: you can fix it in a short period of time. Estate planning isn't just for rich people, it's for smart people. And if you're hearing this, that's probably you. Plan now. Chill later. Your future self says thanks.
This is a guide to setting up an irrevocable trust. When planning for your financial future, it's important to consider how your assets will be managed and distributed. One option to ensure your estate is handled according to your wishes is by setting up an irrevocable trust. The process of setting up an irrevocable trust. Establishing an irrevocable trust can be a complex process that requires a comprehensive understanding of specific laws and procedures. This involves determining the trust's beneficiaries and transferring asset ownership into the trust. Guidance from a knowledgeable lawyer can make the process easier to navigate. Each trust is created for a unique purpose, whether to minimize estate taxes, to provide for a special needs family member, or to protect assets from creditors. Determining your purpose is essential to guide the rest of the setup process. Next, select the right type of irrevocable trust. There are various types of irrevocable trusts, such as charitable remainder trusts, life insurance trusts, and qualified personal residence trusts. Each trust has its pros and cons, and an experienced attorney can help you decide the most suitable one for your circumstances. The next step is to choose your trust. The trustee is the individual responsible for managing the trust based on your guidelines. This could be a trusted friend, a family member, or a professional trustee like a bank or trust company. The chosen trustee should be reliable, honest, and well organized. Next, you need to identify your beneficiaries. Beneficiaries are those who will ultimately receive the assets in the trust. It's crucial to clearly specify who these beneficiaries are and what they are entitled to receive. Next, you will need to create and sign your trust document. The trust document is the legal agreement that outlines the trust's terms, including the trustee's responsibilities and the beneficiary's rights. After the document is drafted to your satisfaction, it must be signed in the presence of a notary. Next, store the trust document safely. After the trust document has been signed, it should be securely stored. Both your trustee and beneficiaries should know its location and how to access it if needed. Next, you will need to transfer assets into the trust. The step of transferring assets into the trust is critical. Depending on the asset type, this may require changing titles or deeds or merely transferring funds. Remember, once an asset is transferred into an irrevocable trust, it generally cannot be removed. Here are some key considerations and benefits. The laws governing the creation and management of irrevocable trusts can vary depending on the state you are located in. Understanding these state-specific laws is essential for ensuring the trust's validity and its ability to meet its intended objectives. When establishing an irrevocable trust, it's crucial to consider the tax implications. Depending on the type of trust and the assets involved, there may be federal and state tax consequences. Now, we'll discuss the benefits of an irrevocable trust. An irrevocable trust is a legal entity that, once established, generally cannot be altered or canceled without the consent of the beneficiary. It offers several benefits like tax advantages, protection from creditors, and assurance that your estate will be managed as you wish. One of the primary advantages of an irrevocable trust is the privacy and asset protection it offers. Because the assets are no longer in your name, they are safeguarded from creditors and legal claims. Do I need a lawyer to set up an irrevocable trust? Establishing an irrevocable trust can be complex and mandates a thorough understanding of the law. A lawyer can guide you through the setup process, ensure all legal stipulations are met, and help you understand the trust's implications. Setting up an irrevocable trust is a comprehensive process that involves understanding various laws, selecting the right type of trust, choosing a competent trustee, and considering both tax implications and asset protection benefits. While it may seem complex, seeking the guidance of a knowledgeable legal expert, like those at Heritage Law Office, can simplify the process and help you achieve your financial and estate planning goals. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching. In this video, we'll explore how to choose the right executor for your estate, covering key considerations and steps to ensure your wishes are carried out. Choosing the right executor is a crucial part of estate planning. Your executor will manage your affairs, settle debts, and distribute your assets according to your will. Making an informed choice can provide peace of mind for you and your loved ones. An executor has several key responsibilities. They collect and manage assets, pay debts and taxes, and distribute assets to beneficiaries. They must act prudently, be impartial, and maintain detailed records. When choosing an executor, look for trustworthiness and integrity. Your executor should be someone you trust implicitly and who has a reputation for honesty. Financial acumen is also essential, especially if your estate includes complex assets. Organizational skills are crucial, as the executor must handle numerous documents and deadlines. They should also be able to handle stress and make sound decisions under pressure. Availability is another key factor, as the role can be time-consuming. Common choices for executors include family members, friends, and professionals. Family members and friends may have a personal interest in honoring your wishes, but it's important to consider their potential emotional strain and conflicts of interest. Professionals, such as lawyers or trust companies, offer expertise and impartiality but come with costs. Consider the size and complexity of your estate when choosing an executor. A large or complicated estate might benefit from a professional executor. Also, think about family dynamics and whether the person you choose can navigate potential conflicts. Geographical proximity can be beneficial, especially if your estate includes real property. Legal requirements vary by state, but generally, an executor must be of legal age, of sound mind, and free of felony convictions. Some states require executors to post a bond to protect the estate from potential mismanagement. You may also appoint co-executors to share responsibilities, but this can lead to conflicts if they disagree. Alternatives to traditional executors include corporate trustees, who provide professional management, and successor executors, who step in if your first choice is unable to serve. To formalize your choice, include your executor in your will, clearly stating their name and any specific instructions. Communicate your decision with your chosen executor and any successors, and review your will periodically to ensure it reflects any changes in circumstances. Avoid common mistakes, such as choosing an executor out of obligation, overlooking professional help, and ignoring potential conflicts of interest. Make a choice based on suitability for the role. Choosing the right executor requires careful consideration and foresight. To ensure your choice is legally sound and well-informed, consult with an experienced attorney. They can guide you through the process and help you select the best candidate for your needs. Thank you for watching. For more information on estate planning, be sure to subscribe to our channel and visit our website. Are you confused about estate planning terms? Stay tuned because we're about to simplify them for you. If you find this information helpful, make sure to subscribe to our channel for more tips on estate planning. What is a will? Let's dive right into it. A will is a legal document that outlines how your assets will be distributed after your death. It's a crucial part of estate planning because it ensures that your property is distributed according to your wishes. Additionally, if you have minor children, a will can specify who will take care of them. In summary, a will is essential for outlining how your assets are distributed and who will take care of your minor children. Next up, what is a trust? A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. There are two main types of trusts: revocable and irrevocable. A revocable trust can be altered or terminated by the grantor during their lifetime, while an irrevocable trust generally cannot be changed once it's established. People often set up trusts to avoid probate, reduce estate taxes, and manage their assets during their lifetime and beyond. Power of attorney. Have you ever wondered what a power of attorney is? A power of attorney is a legal document that grants someone else the authority to act on your behalf in financial or legal matters. This person is known as your agent or attorney, in fact. There are different types of powers of attorney, including a durable power of attorney, which remains in effect if you become incapacitated, a springing power of attorney, which comes into effect upon certain circumstances, a financial power of attorney, which specifically covers financial decisions, and a medical power of attorney, which specifically covers medical decisions. Now, let's talk about beneficiary designation. A beneficiary designation is a legal mechanism for naming individuals or entities to receive certain assets upon your death. Common assets that have beneficiary designations include life insurance policies, retirement accounts, and bank accounts. Beneficiary designations are important because they can override your will, so it's crucial to keep them up to date. Healthcare directive. Finally, what is a healthcare directive? A healthcare directive, also known as a living will or advance directive, is a legal document that specifies your wishes regarding medical treatment if you become unable to communicate those decisions yourself. It typically includes instructions on life-sustaining treatments and end-of-life care. Having a healthcare directive ensures that your medical care preferences are known and respected. These are just a few key estate planning terms, but they form the foundation of a comprehensive estate plan. Understanding these terms can help you take control of your future and protect your loved ones.
Welcome to our comprehensive guide on estate planning. This presentation aims to provide you with essential knowledge to ensure peace of mind for you and your loved ones. Let's explore the key aspects of estate planning and how it can benefit you. Estate planning involves arranging for the management and disposal of your estate after death or incapacitation. It ensures your wishes are followed and helps minimize taxes, legal fees, and family disputes. Let's delve into why this process is crucial. Estate planning is vital as it protects your loved ones and assets. It helps avoid probate, designates guardians for minor children, and ensures healthcare decisions align with your values. Understanding these benefits is key to effective planning. An estate plan comprises several key components: a will, trusts, power of attorney, healthcare directives, beneficiary designations, and a letter of intent. Each plays a crucial role in ensuring your wishes are respected and executed properly. A will is a legal document specifying asset distribution. It appoints an executor and names guardians for children. However, it must go through probate, which can be time-consuming and costly. Understanding its role is essential in estate planning. Trusts help avoid probate and provide more control over asset distribution. They come in various types, including revocable, irrevocable, special needs, and charitable trusts. Each serves different purposes and offers unique benefits. A power of attorney, POA, appoints someone to handle financial and legal matters if you're incapacitated. A durable POA remains in effect after incapacity, ensuring your affairs are managed according to your wishes. Healthcare directives include a living will, which outlines end-of-life care preferences, and a healthcare proxy, which appoints someone to make medical decisions on your behalf. These documents ensure your healthcare wishes are respected. Beneficiary designations apply to life insurance, retirement accounts, and some bank accounts. They supersede your will, so it's crucial to keep them updated to reflect your current wishes and avoid unintended consequences. Estate taxes can significantly impact your estate's value. The federal estate tax threshold is $13.61 million as of 2025, but this is subject to change. Some states have their own taxes. Using trusts and gifting strategies can reduce tax liability. Avoid common estate planning mistakes: not having a plan, forgetting to update documents, ignoring digital assets, not considering long-term care, and choosing the wrong executor or trustee. Awareness of these pitfalls is crucial. Creating an estate plan involves several steps: taking inventory of assets and debts, identifying goals and priorities, choosing beneficiaries, drafting legal documents, and reviewing regularly. Each step is vital for a comprehensive plan. Update your estate plan during major life events: marriage, divorce, birth or adoption of a child, major asset changes, death of a family member, or changes in tax laws. Regular updates ensure your plan remains relevant and effective. Working with professionals can enhance your estate planning process. Consider consulting an estate planning attorney, financial advisor, tax professional, and trust officer. Their expertise can provide valuable insights and guidance. Final thoughts: estate planning is not just for the wealthy. Start early and review regularly to protect what matters most: your people and your wishes. A well-crafted plan ensures peace of mind for you and your loved ones. We now open the floor for questions. For further assistance, please contact the Heritage Law Office. We're here to help you navigate the complexities of estate planning and ensure your wishes are honored.
In this video, we will discuss setting up a trust, the different types available, their benefits, and how you can get started. A trust is a legal arrangement where one party, the trustee, holds and manages assets for the benefit of another party, the beneficiary. The person who creates the trust, known as the grantor, transfers their assets into the trust, which are then managed according to the terms set forth in the trust document. Let's dive into the types of trusts you can set up. First, we have revocable trusts. These allow the grantor to retain control over the assets and make changes to the trust as needed. They are flexible and can be altered or revoked entirely during the grantor's lifetime. However, they do not offer protection from creditors and are included in the grantor's estate for tax purposes. Next, irrevocable trusts. These cannot be modified or terminated without the permission of the beneficiaries once established. They offer strong asset protection and potential tax benefits, but less flexibility since the grantor loses control over the assets. Charitable trusts are designed to benefit a specific charity or the public. They provide significant tax benefits to the grantor and can offer income to the grantor or beneficiaries. A special needs trust provides for a disabled beneficiary without disqualifying them from government assistance programs like Medicaid or SSI. It preserves eligibility for public benefits while providing for the beneficiary's supplemental needs. Finally, spendthrift trusts protect the trust assets from being claimed by creditors of the beneficiary and help manage the distribution to prevent reckless spending by the beneficiary. Now, let's talk about the benefits of setting up a trust. Trusts can help you avoid probate, saving time and reducing legal costs. They offer privacy since they are private documents and do not become part of the public record. Certain trusts can protect assets from creditors and lawsuits. They also provide tax advantages, potentially reducing estate and gift taxes. Trusts allow detailed instructions on how and when assets are distributed to beneficiaries and offer flexibility to change terms as circumstances evolve. Setting up a trust involves several key steps. First, determine your goals. Identify your primary objectives, such as avoiding probate, protecting assets, or supporting a charitable cause. This will help you choose the type of trust that best suits your needs. Next, choose the type of trust based on your goals. Consult with an experienced attorney to understand the advantages and disadvantages of each type. Draft the trust document with an attorney, outlining the terms, including the trustee's responsibilities, the beneficiaries, and the distribution of assets. Fund the trust by transferring the chosen assets into it. This step is crucial as the trust will not be effective until properly funded. Appoint a trustworthy and reliable individual or institution as the trustee. The trustee will be responsible for administering the trust according to its terms. Sign and notarize the trust document to make it legally binding. Depending on state laws, notarization may be required. Update beneficiary designations to ensure all beneficiary designations on accounts, insurance policies, and other assets align with the trust. Finally, inform your beneficiaries about the existence of the trust and its general terms. While you may not need to share specific details, it's helpful for them to understand their roles and what to expect in the future. To recap, trusts offer numerous benefits, including avoiding probate, providing privacy, protecting assets, offering tax advantages, and giving you control over asset distribution. Setting up a trust involves several steps, from determining your goals to informing your beneficiaries. Thank you for watching. If you found this video helpful, please like and subscribe for more.
Is a Medicaid asset protection trust worth it? Let's do the math. A typical nursing home stay costs $9,000 to $11,000 per month. That's over $100,000 a year. 70% of people over 65 will need nursing home care at some point. 1 in 5 will need care for more than 5 years. We help clients set up a Medicaid Asset Protection Trust for $8,500. A one-time cost that can protect your home or savings from being spent down in long-term care. If Medicaid covers your nursing home bill even 1 month earlier than it would have without the trust, you've already recovered the cost. Stay 6 months in a facility? You could save over $50,000 in protected assets. Stay 12 months? That number doubles. It's not just about the money. It's about peace of mind, preserving your legacy, and having options.
A will is a legal document that outlines your desires for distribution of your estate after your passing. Failure to create a will puts your estate in the hands of courts or state officials, which can lead to family turmoil. To be completely sure everything is correct, you should have your will prepared by a trust's and estate's attorney. Some people believe that wills are only necessary for the very wealthy or those with complicated assets. However, there are many good reasons to have a will. You can be clear about who gets your assets. You have more control and can decide who gets what and how much. Your heirs will be able to access your assets more quickly and easily. Additionally, with proper planning, you can plan to save your estate money on taxes. You can also give gifts and charitable donations, which can give tax benefits. However, even if you have a will, upon your passing, your assets will be routed through the probate process. Probate is the legal process that occurs to your estate after you pass away. This is a court-monitored process where the debts of the estate are paid and distribution is made to the heirs. The probate process will flow smoother with a will. Probate costs money and can take significant time. With proper estate planning, probate may be able to be avoided. Trusts can accomplish the same goals as a will, but oftentimes in much better fashion. When a trust is properly set up, it can avoid probate entirely. Any assets that belong to the trust will not be routed through probate. Often, a type of will, a pour-over will, is used in conjunction with creating a trust to ensure all assets are covered, even if they are not properly moved to a trust. To ensure your will or trust is done properly, contact Heritage Law Office today.
Welcome to our series on estate planning. Today, we're going to discuss digital estate planning and how to manage your digital assets and online accounts in your estate plan. In our digital age, it's crucial to include these assets in your planning. First, what are digital assets? Digital assets include anything stored electronically, such as email accounts, social media profiles, online banking, digital currencies, and more. These assets fall into several categories: personal, financial, social media, and business-related. To begin, identify your digital assets. Create an inventory listing all your digital assets along with usernames, passwords, and security questions. This inventory will be essential for your executor or beneficiaries to access and manage these assets after you're gone. Legal considerations are also important. The legal framework surrounding digital assets can be complex. Laws such as the Revised Uniform Fiduciary Access to Digital Assets Act, RUFADAA, help govern how digital assets are handled after death. Understanding these laws will help you create a more effective digital estate plan. Access and control are crucial elements. Ensure your executor or beneficiaries can access your digital assets. Use password managers and secure storage solutions to store your login information. This makes it easier for your trusted individuals to access your accounts when needed. Include specific instructions for handling your digital assets in your estate plan. For social media accounts, you may want to specify whether they should be memorialized or deleted. For email accounts, provide clear instructions on how to manage or close them. For online banking and digital currencies, outline how these assets should be transferred or accessed. Appointing a digital executor is another key step. A digital executor is responsible for managing your digital assets according to your wishes. Choose someone tech-savvy and trustworthy. Clearly outline their responsibilities and the extent of their authority in your estate plan. Regularly update your digital estate plan. Review and update your digital asset inventory to reflect new accounts, changes in passwords, and other updates. This ensures your plan remains current and effective. Protecting privacy and security is paramount. Take steps to protect your digital assets against identity theft and data breaches. Use strong, unique passwords, enable two-factor authentication, and store your inventory in a secure location. Communication is essential. Inform your executor and beneficiaries about your digital estate plan. Provide them with access instructions and necessary documentation to ensure they can manage your digital assets effectively. Let's look at a real-life example. Imagine someone who has significant online assets, including a blog generating income, multiple social media accounts, and digital currencies. By creating a digital estate plan, they ensure their digital executor can access these assets, manage them according to their wishes, and distribute any financial benefits to their beneficiaries. In summary, digital estate planning involves identifying your digital assets, providing access and control, including specific instructions in your estate plan, appointing a digital executor, regularly updating your plan, and protecting privacy and security. By including digital assets in your estate plan, you can ensure a smooth transition and protect your digital legacy. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
In many families, it's customary to pass on the family home to surviving children after the parent's death. You may be considering how to give your child or children your home without the sting of taxes later. It is possible, and there are a few ways to accomplish it, but it takes some advanced planning to make sure everything happens in a way that provides the most benefits to your family. You may be concerned about Medicaid taking your house or spending down your assets to receive Medicaid benefits. Estate recovery occurs after your death, when the state goes through your assets to recover costs of your long-term nursing home care while you were alive. Since a house is often the only major asset many individuals have, frequently the home is sold and the funds are used to repay Medicare. However, you can protect your home from a Medicaid estate recovery and sale. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children, or anyone else, while you're alive. You can live in it, or rent it out, during your lifetime, and when you die, the remaining ownership passes to your kids, or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible. You can gift a maximum of $15,000 in 2018, but gifting more does not necessarily warrant the payment of taxes, however. Contact an attorney at Heritage Law Office for a free consultation. Many people ask, should you put your house in a trust? The answer is probably yes, and in certain situations, the answer is a resounding yes. One of the wonderful things about revocable living trusts is there are very few downsides. If you are not familiar with a revocable living trust, think of a trust as a bucket. The bucket can hold your assets and contain a set of rules and instructions for what happens with the assets upon your passing. In that respect, the trust can function like a will in that it passes your assets to your beneficiaries. However, a revocable living trust has many benefits over a will, which may make placing your house in a trust a wise decision. For example, to administer a will, it is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate. This means it is no longer your asset from a legal standpoint. The house is owned by the irrevocable trust itself, similar to how a corporation can own an asset. Since you no longer own or have control of the asset, the home may be able to be protected from creditors or if you want to apply for Medicaid. Both revocable and irrevocable trusts are important parts of proper estate planning. However, for trusts to function, they must be used and set up properly. Improper use can have a substantial negative effect on your estate. Contact one of our attorneys to make sure your assets are properly protected.
In this video, we will explore the essential differences between trusts and wills and answer some common questions to help you understand these important estate planning tools. A will is a legal document that outlines how your assets will be distributed after your death. It must go through the probate process, which can be time-consuming and public. A trust, on the other hand, is a legal arrangement where one party holds and manages assets on behalf of another. Trusts can often avoid probate, providing a quicker and more private way to distribute assets. So, do you need both a will and a trust? The answer depends on your unique circumstances. Wills are crucial for naming guardians for minor children and specifying final arrangements. Trusts, however, can manage and distribute assets efficiently and provide benefits during your lifetime, especially if you become incapacitated. Having both can ensure comprehensive coverage for your estate. Now let's look at the different types of trusts and their benefits. Revocable trusts or living trusts can be altered during your lifetime and help avoid probate. Irrevocable trusts, which cannot be changed once established, offer asset protection and tax benefits. Charitable trusts support philanthropic goals and provide tax deductions. Testamentary trusts are created through a will and take effect upon your death. Special needs trusts ensure care for a beneficiary with special needs without affecting government benefits. Medicaid asset protection trusts help protect assets for Medicaid eligibility. Trusts can also be an effective tool for minimizing estate taxes. Irrevocable trusts, for instance, remove assets from your taxable estate, potentially reducing your estate tax burden. Charitable trusts can provide both estate tax benefits and charitable deductions. Specialized trusts like grantor retained annuity trusts, or GRATs, and qualified personal residence trusts, or QPRTs, can also help reduce estate taxes. However, not all assets can be placed in a trust. Retirement accounts like IRAs and 401ks typically cannot be transferred into a trust without triggering taxes. Your primary residence can be transferred into a trust, but it requires careful planning to avoid losing homestead exemptions. While vehicles can be placed in a trust, it can be complex and might not be necessary. Choosing the right trustee or executor is crucial for the smooth administration of your estate. Look for someone trustworthy, with financial acumen, and who is available and willing to fulfill their duties. Impartiality is also important, especially in families where potential conflicts may arise. Professional or corporate trustees are an option if you do not have a suitable individual in mind. It's also essential to regularly update your will or trust. Major life events like marriage, divorce, the birth or adoption of a child, significant financial changes, or moving to a different state can impact your estate plan. Regular reviews with your attorney can ensure your documents remain up to date and effective. Understanding the differences between wills and trusts and knowing when to use each is vital for effective estate planning. Trusts and wills can work together to provide a comprehensive plan that addresses all your needs. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you in the next. In this video, we will explain personal trusts, their types, benefits, and how to create one. Stay tuned to learn how trusts can help you manage and protect your assets. A personal trust is a legal arrangement where a trustee holds and manages assets for the benefit of a beneficiary. The person who creates the trust, known as the grantor, transfers their assets into the trust. There are several types of personal trusts, each with unique benefits. Revocable trusts allow the grantor to retain control and make changes during their lifetime. This type of trust helps avoid probate, provides privacy, and can be amended as needed. Irrevocable trusts, on the other hand, cannot be altered once established. These trusts offer greater asset protection and tax benefits, but reduce the grantor's control over the assets. Charitable trusts benefit a charitable organization while providing tax advantages to the grantor. They support philanthropic goals and offer income tax deductions. Special needs trusts are designed for disabled beneficiaries, ensuring they receive financial support without affecting their eligibility for government benefits like SSI and Medicaid. Testamentary trusts are created through a will and take effect after the grantor's death. They are often used to provide for minor children and manage assets for dependents. Spendthrift trusts protect the beneficiary's inheritance by limiting their access to the trust principal, ensuring long-term financial support. Personal trusts offer several key benefits, including asset protection, tax efficiency, control and flexibility, privacy, and support for beneficiaries. Creating and managing a personal trust involves several steps. First, determine your goals and choose the type of trust that best meets your needs. Select a reliable trustee and work with an attorney to draft the trust document. Fund the trust by transferring ownership of your assets into it, and maintain the trust by complying with its terms and making necessary distributions. Personal trusts can be used for estate planning, asset protection, tax planning, long-term care planning, and business succession. Selecting the right trustee is crucial. Look for qualities like integrity, financial acumen, impartiality, and good communication skills. You can choose an individual trustee, a corporate trustee, or a combination of both as co-trustees. To recap, personal trusts are a powerful tool for managing and protecting your assets. They offer numerous benefits and can be tailored to meet your specific needs. If you're considering setting up a trust, contact a personal trust attorney to get started. Thank you for watching. Don't forget to like and subscribe for more helpful videos.
Did you know there's a legal hack in estate planning that can save your family thousands without changing your will or trust? It's called Transfer on Death Designation, or TOD, and almost no one talks about it. Here's how it works. You can add a TOD designation to your bank accounts, investment accounts, and even your car title in some states. When you pass away, those assets go directly to your chosen beneficiary. No probate, no court delays, no lawyer fees. It's as simple as filling out a form with your bank or DMV. That's it. And the best part? It costs nothing to set up. So if you want to protect your family from months of court headaches and thousands in legal fees, look into TODs today. Follow for more estate planning tips that actually save you money.
Are you unsure whether a will or a trust is the best choice for your estate planning? In this video, we'll explore the key differences between wills and trusts to help you make an informed decision. First, let's talk about wills. A will is a legal document that outlines how you want your assets distributed after your death. It can include instructions for distributing personal property, naming guardians for minor children, and specifying funeral arrangements. One of the main advantages of a will is its simplicity and ease of creation. However, it's important to note that wills must go through the probate process, which can be time-consuming and public. Next, we have trusts. A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of beneficiaries. There are two main types of trusts, revocable and irrevocable. A revocable trust can be altered or dissolved by the grantor during their lifetime, offering flexibility and control. An irrevocable trust, on the other hand, cannot be easily altered once established, providing greater asset protection and tax benefits. Trusts generally bypass the probate process, offering privacy and potentially faster distribution of assets. When comparing wills and trusts, there are several factors to consider. Cost is one aspect. While wills are generally less expensive to create, trusts can save money in the long run by avoiding probate fees. Flexibility and control also vary, with wills being easier to amend, but trusts offering more control over asset distribution during your lifetime and after. Privacy is another significant difference. Wills become public record through probate, whereas trusts remain private. Additionally, the management and distribution of assets can be more streamlined with trusts, especially for complex estates. So, how do you choose the right option? Here are some questions to help you decide. What are your estate planning goals? If your primary goal is to ensure your assets are distributed quickly and privately, a trust may be the right choice. How do you feel about the probate process? Trusts can help your beneficiaries avoid the time-consuming and often costly probate process. Do you have minor children or dependents with special needs? Trusts can offer more control over how and when your assets are distributed, ensuring your children or dependents are cared for according to your wishes. What is the size and complexity of your estate? Larger estates might benefit more from the flexibility and control that a trust provides. Are you concerned about privacy? Trusts do not become public record like wills during the probate process. In conclusion, both wills and trusts have their unique advantages and can be tailored to meet your specific needs. It's always wise to seek professional legal advice to make an informed decision. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. A charitable remainder trust is an irrevocable trust that provides the donor with income for life and a current tax benefit for planning to donate assets upon their death. The donor gives away assets to an irrevocable trust, and during their lifetime they receive income from the trust. When they die, the remainder in the trust goes to the charities of their choice. When an asset is transferred into an irrevocable trust, it is removed from their estate. As a result, The assets in the trust cannot be recovered by creditors, and no estate taxes will be due upon their death. Additionally, because the assets are no longer owned by the donor, other advanced estate planning methods may be used in conjunction with a charitable remainder trust. Finally, for their generosity, the donor will receive an immediate income tax deduction when the charitable remainder trust is funded. The tax deduction amount is based on the current value of the assets that will go to charity. Irrevocable trusts are complex and must be precise. Be sure to talk with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
In this video, we'll talk about what you need to know about the advantages and disadvantages of establishing a trust. If you're contemplating setting up a trust, this video is designed to help you make a more informed decision. Let's get started. What is a trust and why is it important? First, let's answer a common question. What exactly is a trust? A trust is a legal arrangement that allows a third party, called a trustee, to hold and manage assets on behalf of beneficiaries. Trusts are commonly used in estate planning, wealth management, and asset protection. They can help individuals achieve various financial and personal objectives, such as providing for loved ones, reducing taxes, or ensuring privacy. Now that you understand what a trust is, let's move on to explore the different types of trusts you can establish. There are many types of trusts, each serving a specific purpose. Some common types include revocable living trusts, irrevocable trusts, testamentary trusts, special needs trusts, charitable trusts. Each type of trust has its own set of advantages. Let's take a closer look. Trusts offer a multitude of benefits. First, they give you significant control and flexibility over how your assets will be managed and distributed. You can establish specific terms and conditions, aligning your trust seamlessly with your unique goals and needs. Another major advantage is probate avoidance. Probate is a legal procedure that validates a will and distributes assets. Trusts, however, bypass this process entirely, enabling a faster and more confidential asset transfer to your beneficiaries. Tax benefits are also on the table. Some trusts can substantially minimize estate, gift, and income taxes. For instance, an irrevocable trust can effectively reduce your taxable estate, offering potential tax savings for your beneficiaries. Lastly, trusts are excellent tools for asset protection. They can shield your assets from creditors, lawsuits, or even divorce proceedings. While trusts offer significant advantages, it's essential to also consider the disadvantages. Complexity and cost. Even though trusts are highly beneficial, they come with some drawbacks. The most glaring ones are their complexity and associated costs. Establishing a trust requires experienced legal guidance, and there may be some administrative fees involved. Additionally, some trusts, particularly irrevocable ones, lack flexibility. Once established, they can't be easily changed or dissolved without the beneficiary's consent. Finally, trusts can sometimes fuel conflicts among family members or beneficiaries, especially if the trust is perceived as unfair or if the trustee is not acting responsibly. Understanding both sides of the coin can help you make a well-informed decision about whether a trust is right for you. A trust can offer numerous advantages, such as control over asset distribution, probate avoidance, potential tax benefits, and asset protection. However, there are some drawbacks to consider, like the complexity and cost of establishing and maintaining the trust, potential irrevocability, and the possibility of conflicts among beneficiaries. For more information on each type of trust, explore some of our other videos where we break these down individually. If you found this video helpful, remember to like and subscribe. Thank you for watching.
Here's one important catch when it comes to gifting your home. If you gift the home during your lifetime, your heirs inherit the original cost basis. This means they'll have to pay capital gains taxes on the appreciation since the day you bought the home, not the day they inherited. Let's say you bought your home 30 years ago for $200,000, and today it's worth $1 million. If you gift it to your child now, they inherit your $200,000 cost basis. If they sell it for $1 million, they'll owe capital gains taxes on $800,000. However, if they inherit it after your passing, the cost basis steps up to the home's current market value of $1 million, meaning they could sell it tax-free. This is why, for many families, holding onto your home and passing it through inheritance, especially with a trust, can be a smarter move than gifting it early.
Life is full of surprises, new relationships, growing families, and unexpected financial windfalls. But have you ever wondered how these life events affect your last will and testament? You're not alone. Delaying the update of your will can cost you dearly, leading to potential asset disputes, loss of money, and legal headaches for your loved ones. Today, we'll make sure that doesn't happen to you. Welcome back to Heritage Law, where we simplify legal matters for your peace of mind. In this video, we'll discuss 3 very important topics for you. The process of updating a will, why it's important to keep it up to date, and common scenarios that may prompt you to make changes. Ready to secure your family's future? Let's get started. Up first, how do I change my will? To begin, a will is a legal document that outlines your wishes for the distribution of your assets and the care of any minor children after your death. But what happens when the will no longer reflects the intentions of the person who created it? There are 2 fundamental methods for updating a will if it no longer aligns with your intention. First, by drafting an entirely new will, or second, by amending the existing will with a document called a codicil. Let's explore these approaches, beginning with the first method, drafting a new will. Drafting a new will is often the favored method for updating an estate plan. However, neglecting to properly revoke the previous will may leave the new will susceptible to court challenges. To prevent such issues, it is essential to clearly revoke the old will. Here are 2 options for doing so. Option 1. Add a revocation clause. Create a new will, and within it, stipulate that you revoke all previous wills. Keep in mind, the new will must meet the same requirements as the initial one, including testamentary intent and capacity, absence of undue influence, fraud, or duress, and proper signatures and witnesses in compliance with the law. And option 2, revocation by destruction. Physically destroying the old will and all copies through means such as burning, shredding, or ripping out the signature. Note that this method does not permit the removal of specific provisions for change or termination. Instead, destruction through a physical act invalidates the entire will. It is still a good idea to include a revocation clause in the new will to clearly state your intentions and avoid any potential legal disputes or confusion. The second approach to modifying a will is by drafting a codicil. A codicil is a supplementary document that makes changes to an existing will. Like a regular will, codicils must show testamentary intent and satisfy all other requirements for validity. However, this method is not preferred because it leaves the person making the will with 2 legal documents. If one of them is lost, it could lead to potential challenges to the will, as codicils are not intended to serve as standalone wills. Now that you've updated your will, what should you do after? After updating your will, it's essential to take steps to secure and protect the document, just as you did with the original will. Store the original and all copies in a safe place, such as a lockbox at home or a safe deposit box at a bank. Inform the executor of the will's location. Keep the original will and its copies separate. Clearly mark copies as duplicates and include a note indicating the location of the original will, and provide a copy to a select few trusted individuals. Although you are not required to give anyone a copy, it's a good idea to leave one with the attorney who drafted the will. Have you taken any steps to secure and protect your will, and do you have any unique methods or additional precautions that you would like to share with the community? Let us know down below. And if you find this video informative and helpful, please give it a thumbs up. It really helps the channel out. Finally, our last question. When should I change my will? Estate planning is an ongoing process, and it's a good idea to revisit the terms of your will at least once a year, even if only to reaffirm them. However, certain life events may necessitate changes to your will, including divorce, marriage or remarriage, the birth of a new child, grandchild, or the addition of stepchildren, a serious and permanent falling out with a beneficiary, receiving a significant amount of property or money since your last will update, and relocating to a state with different marital property laws. Pause here for the full list. Failing to update your will after these events could lead to unintended consequences, such as assets being distributed to an ex-spouse rather than your current spouse or children, disinheriting a child or grandchild accidentally, leaving your estate to people you no longer have a relationship with, or by unintentionally excluding new family members, and a lengthy legal battle among your loved ones to determine your true intentions. Pause here again for the full list. It's crucial to keep your will up to date as your life circumstances and intentions change. Otherwise, you risk putting your family and loved ones through unnecessary stress and legal complications. Whether you choose to draft an entirely new will or amend your existing one with a codicil, it's essential to follow the proper legal procedures to ensure your wishes are honored. Don't hesitate to explore our extensive collection of in-depth articles, insightful guides, and useful resources at heritagelawoffice.com. If you found this video beneficial, you're sure to appreciate our next video, Pass Down Your Home Tax-Free, recommended right here. Don't miss out, it's packed with useful information. Don't forget to like and subscribe to this channel for more beneficial videos in the future. Thank you for joining us, and we look forward to helping you protect your family's legacy. In this video, we will discuss the top benefits of having a will. Creating a will is an essential step in ensuring that your wishes are respected and your loved ones are taken care of after you're gone. It is a critical part of estate planning that can save your family from unnecessary stress and conflict. Having a will provides peace of mind, knowing that your wishes will be followed after you're gone. For instance, imagine a family where the primary breadwinner passes away without a will. The family might face legal hurdles and financial uncertainties, adding to their grief. A will can prevent such scenarios by clearly outlining your wishes. A will helps avoid family disputes. Without a will, disagreements about asset distribution can lead to lasting rifts in family relationships. When your intentions are clearly outlined, there's less room for misunderstandings and disagreements among family members, ensuring a smoother transition during a difficult time. By having a will, you maintain control over the distribution of your assets. You decide who gets what and how much, making sure that your belongings, whether they are properties, family heirlooms, or financial assets, go exactly where you want them to go. This prevents the state from making these decisions for you. If you have minor children, a will is crucial for naming a guardian. This ensures that someone you trust will take care of your children, rather than leaving the decision to the courts. The emotional and legal security provided by naming a guardian cannot be overstated. A will can also speed up the probate process. Probate is the legal process of distributing your assets after death. By clearly stating your wishes, you help streamline the legal proceedings, reducing the time and cost associated with probate. This can significantly ease the burden on your loved ones during an already difficult time. Including charitable contributions in your will is another benefit. You can leave a legacy by donating to causes that matter to you, making a positive impact even after you're gone. In summary, having a will provides peace of mind, helps avoid family disputes, allows you to control asset distribution, ensures guardianship for minor children, speeds up the probate process, and enables charitable contributions.
Most people think once they've written a will, they're done. But here's the biggest mistake. They never update it. Life changes fast. Got married, had a child, got divorced, bought a house. All of these are reasons to review your will. An outdated will can cause confusion, delays, or even get challenged in court. Set a reminder to check your will every few years, or any time your life changes. It's a simple habit that can save your family a lot of stress later.
In this video, we will discuss the top estate planning mistakes to avoid. Estate planning is essential to ensure your assets are distributed according to your wishes and to avoid potential legal complications. Let's dive into the common mistakes and how to avoid them. One of the biggest mistakes you can make is failing to create an estate plan. Without a plan, the state decides how your assets are distributed, which may not align with your wishes. It's crucial to start early and consult with an experienced attorney to ensure all aspects of your estate are covered. Another common mistake is not updating your estate plan regularly. Life changes such as marriage, divorce, the birth of a child, or the death of a beneficiary can significantly impact your estate plan. Make sure to review and update your plan at least once a year or after any major life event. Overlooking a living will and healthcare directive is another critical mistake. These documents outline your wishes regarding medical treatment if you become incapacitated. Ensure your estate plan includes a living will and a healthcare directive, and communicate your healthcare wishes with your family and designated healthcare proxy. Ignoring tax implications can also be detrimental. Failing to consider how taxes will affect your estate can result in your beneficiaries receiving less than you intended. Educate yourself on estate taxes and use strategies, such as trusts, to manage tax liabilities effectively. Not designating beneficiaries properly is a common issue that can lead to disputes and delays. Clearly name both primary and secondary beneficiaries for all your accounts and update this information regularly, especially after major life events. Planning for incapacity is often overlooked. Without a plan, you risk having a court-appointed guardian make decisions on your behalf. Establish powers of attorney for both financial and healthcare decisions, and choose trustworthy individuals to act in your best interest. In today's digital age, it's crucial to include digital assets in your estate plan. Make a comprehensive list of your digital assets and ensure your executor has the necessary information to access and manage them. Long-term care costs can quickly deplete your estate if not planned for. Consider purchasing long-term care insurance and setting up Medicaid asset protection trusts to safeguard your assets from these expenses. Poor trust management can lead to legal complications and unintended consequences for your beneficiaries. Educate yourself on the duties and liabilities of trustees and appoint trustworthy and knowledgeable individuals to manage your trusts. By avoiding these common estate planning mistakes, you can ensure your assets are protected and distributed according to your wishes. Seek professional guidance to create a comprehensive estate plan that secures your financial future and provides peace of mind for you and your loved ones. Thank you for watching. If you found this video helpful, please like and subscribe for more estate planning tips.
In this video, we will explore the probate process and the responsibilities of an executor. Probate is a legal procedure that takes place after someone passes away. It involves validating their will and administering their estate to ensure their assets are distributed as intended or according to state law if there's no will. The probate process has several key components. These include validating the will, appointing an executor, inventorying the assets, paying debts and taxes, and finally, distributing the remaining assets to beneficiaries. An executor plays a crucial role in managing the decedent's estate. Their responsibilities include filing the will with the probate court, notifying beneficiaries and creditors, managing the estate's assets, paying any outstanding debts and taxes, and distributing the remaining assets to the rightful heirs. Let's break down the probate process step by step. First, the executor files a petition with the probate court to open probate and get appointed if they haven't been named in the will. Next, the executor must notify all interested parties, including beneficiaries and creditors, about the probate proceedings. The executor then takes inventory of all the decedent's assets, which includes real estate, personal property, and financial accounts. This inventory is submitted to the court. In many cases, these assets need to be appraised to determine their fair market value. This step is essential for accurate tax assessment. The executor must then pay any valid debts and taxes owed by the estate, such as final income taxes and estate taxes. Finally, after all debts and taxes are settled, the remaining assets can be distributed to the beneficiaries according to the will or state intestacy laws. However, the probate process can present several challenges. These include will contests, the complexity of assets, debt management, potential executor misconduct, and lack of proper documentation. To avoid probate, you can consider several strategies: setting up a revocable living trust, holding assets in joint ownership with rights of survivorship, naming beneficiaries on financial accounts, and using payable on death accounts are all effective methods. Understanding and navigating the probate process can be daunting, but with the right guidance, it becomes manageable. Thank you for watching. Be sure to like and subscribe for more informative legal content.
Medicaid provides health coverage to millions of Americans, including eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Medicaid is administered by states according to federal requirements. The program is funded jointly by states and the federal government. The Medicaid system will pay for your care costs, including a stay in a nursing home if you meet certain qualifications. The Medicaid system has an asset limit. As of the day this video was produced, as an unmarried person in Wisconsin, you must have less than $2,000 in assets to qualify for Medicaid. If you have more than $2,000 of assets, you must first spend your assets on qualifying expenses until you drop below the asset limit. Once you drop below the asset limit, the Medicaid system will cover your costs. Assets are separated into two categories: countable and non-countable. Countable assets count towards the asset limit of $2,000. Some examples of a countable asset may include cash, your bank accounts, and stocks. Non-countable assets do not count towards the asset limit of $2,000. Some examples of a non-countable asset may include a first automobile, money prepaid for funeral expenses, or a primary residence if a spouse still resides in that home. One of the methods in pre-planning for Medicaid is to strategically turn your countable assets to non-countable assets. Doing this will help preserve the value of your assets, while dropping you below the asset limit, qualifying you for Medicaid benefits. We work with you to find the best methods and options of converting assets to non-countable assets to preserve the most value for you and fit your specific needs. Contact one of our attorneys at our Wisconsin, Minnesota, or California locations to make sure your assets are properly protected. And for more information on wills, trusts, life estates, Medicaid planning, and estate planning.
Thinking about how to protect your assets and make life easier for your loved ones? A revocable trust might be the answer. A revocable trust lets you transfer ownership of your assets, like your home and bank accounts, into a trust while keeping full control. You can buy, sell, or move assets in and out of the trust just like always. And since it's revocable, you can change or cancel it anytime you want. One major benefit? Avoiding probate. It's the court process that can be time-consuming and expensive when someone dies with just a will. With a revocable trust, your assets pass directly to your beneficiaries, meaning less hassle and more privacy for your loved ones. Plus, if you become incapacitated, you can name a successor trustee to manage your affairs, avoiding confusion and family conflict.
Probate is the legal process that occurs to your estate after you pass away. During this legal process, a court will monitor the process of paying your debts and distributing your estate to the proper heirs. The probate process will take several months at minimum to complete and may take longer, depending on the complexity of your estate. Through proper planning, probate can be avoided, saving time and money. Tools such as a trust, life estate, joint ownership, and payable or transfer on death designations may be able to avoid probate. A will does not avoid probate as it is designed to go through the probate process. Speak to a professional today. Understanding special needs trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or SNT, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are three main types of special needs trusts. First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential, with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. It provides financial security and enhances the quality of life for individuals with disabilities. In this video, we will discuss the essential components of a strong estate plan and how each component can help you ensure your wishes are fulfilled. Creating an estate plan is crucial to ensure your assets are distributed according to your wishes after you pass away. Without an estate plan, the state will determine how your assets are distributed, which may not align with your intentions. Having a clear plan can give you peace of mind and prevent potential conflicts among your heirs. A will is a legal document that outlines how you want your assets distributed after your death. It is essential to include key elements such as the designation of an executor, guardianship for minor children, and specific bequests. A well-drafted will can ensure your loved ones are taken care of and your assets are distributed as you desire. Trusts are another vital component of an estate plan. They come in different forms, such as revocable and irrevocable trusts. Trusts can help manage your assets during your lifetime and ensure they are distributed efficiently after your death, often avoiding probate. By setting up a trust, you can control how and when your beneficiaries receive their inheritance, protect assets from creditors, and potentially reduce estate taxes. Powers of attorney are critical for managing your affairs if you become incapacitated. Financial powers of attorney allow someone to manage your financial matters, while healthcare powers of attorney enable someone to make medical decisions on your behalf. Having these documents in place ensures your affairs are handled according to your wishes, even if you are unable to communicate them yourself. Healthcare directives, including living wills and healthcare proxies, are essential for outlining your medical preferences in case you cannot communicate your wishes. These documents guide your loved ones and healthcare providers in making crucial medical decisions, ensuring your healthcare wishes are respected. Ensure your assets go to the intended recipients by updating beneficiary designations on accounts such as life insurance policies, retirement accounts, and payable on death bank accounts. This step helps avoid probate and ensures a smooth transfer of assets. Regularly updating these designations can prevent unintended beneficiaries from inheriting your assets. It's important to review and update your estate plan periodically. Major life events such as marriage, divorce, the birth of a child, or the death of a loved one may necessitate changes to your plan to reflect your current wishes and circumstances. Regular reviews help ensure your estate plan remains aligned with your evolving needs and goals. In summary, a strong estate plan includes a will, various types of trusts, powers of attorney, healthcare directives, and updated beneficiary designations. Regularly reviewing and updating your plan ensures it remains aligned with your wishes. Contact us to learn more about creating a comprehensive estate plan tailored to your needs. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. Revocable trusts are often used to get the effects that most people are searching for when they get a will. Wills have an issue when compared to trusts in that, by law, they are routed through the probate process, which takes significant time and money. Probate is the legal process that occurs to your estate after you pass away. A properly designed and funded trust can completely avoid probate, bypassing the need for mandatory waiting periods, your information being publicly disclosed, and having the entire process monitored by a court. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
Welcome back to our series on estate planning for business owners. In our last video, we discussed what business succession planning is and why it's crucial. Today, we're going to walk you through the steps for creating a robust business succession plan. Step 1. Identify potential successors. Start by evaluating who could take over your business. This could be a family member, a key employee, a business partner, or an outside buyer. Consider their skills, experience, and commitment to the business. It's essential to choose someone who can maintain and grow the business successfully. Step 2. Define your goals and vision for the future. Think about what you want to achieve with your succession plan. Do you want to keep the business in the family, sell it for the highest value, or ensure a smooth transition to a trusted employee? Clearly outlining your goals will help guide the planning process. Step 3. Develop a formal succession plan. This plan should include legal documents and agreements that outline how the transfer of ownership and management will occur. A key document in this process is the buy-sell agreement. This agreement specifies how a partner's share of the business may be reassigned if that partner dies or leaves the business, detailing the conditions under which the transfer will take place. Step 4. Conduct a business valuation. Understanding the value of your business is crucial for the succession plan. A professional valuation will provide an accurate picture of what your business is worth, which is essential for buy-sell agreements, estate planning, and setting a fair price if the business is sold to an outside party. Step 5. Plan for funding the succession. Determine how the successor will finance the purchase of the business, if applicable. Options include installment sales, loans, or using life insurance policies. For instance, a life insurance-funded buy-sell agreement can provide the necessary liquidity to buy out a deceased owner's share of the business without straining the company's finances. Step 6. Prepare your successor. Start training and mentoring your chosen successor well in advance of your planned transition. This ensures they have the knowledge, skills, and experience to lead the business. Gradually increasing their responsibilities can help them gain confidence and be better prepared for the leadership role. Step 7. Communicate the plan. Share your succession plan with key stakeholders, including family members, employees, business partners, and advisors. Clear communication helps prevent misunderstandings and conflicts, ensuring everyone understands and supports the plan. Step 8. Review and update the plan regularly. Business and personal circumstances can change, so it's important to review and update your succession plan periodically. This ensures the plan remains relevant and effective in achieving your goals. Creating a business succession plan is a complex but essential task for ensuring the longevity and success of your business. By following these steps, you can create a comprehensive plan that provides a smooth transition of ownership and management, protects your business's value, and achieves your personal and financial goals. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
When you pass away, your debts do not expire with you. Most debt still needs to be paid off if possible, although who is responsible for paying the debt depends on the type of debt, and some assets are protected from being used to satisfy a debt. Outstanding debt may include mortgages, credit card bills, car loans, personal loans, or condominium fees. Usually, your estate is responsible for paying any debts you leave behind. If the estate does not have enough money, the debts will go unpaid. In general, debt collectors may not try to collect payment from your relatives and heirs. However, there are some exceptions. Co-signers and guarantors of a particular debt are responsible for that debt, and someone who held property jointly with you would be responsible for any debts on the joint property. In addition, spouses in community property states may be responsible for some debt. Creditors are paid from the part of your estate that passes through probate, which means any property that passes through a will. The person who is appointed personal representative or executor of your estate is responsible for making sure the creditors are paid. The personal representative uses estate assets to pay off the debts before any money passes to heirs. If you have significant debts, it is possible that your entire estate will be used to pay creditors. Creditors cannot be paid from any assets that pass directly to a beneficiary. For example, a jointly held bank account would pass directly to the joint owner, and the funds in that account could not be used to pay creditors. Similarly, life insurance policies pass directly to the beneficiaries, so creditors do not have access to those funds. Whether or not a creditor can access funds in a trust depends on state law as well as what kind of trust it is. Contact Heritage Law Office to make sure your assets are protected. In this video, we will explain what estate taxes are and provide strategies to minimize them for 2024. Estate taxes are levied on the transfer of property upon the death of the owner. They are calculated based on the total value of the deceased person's estate, including cash, real estate, stocks, bonds, and other valuable assets. Understanding these taxes is crucial for effective estate planning, as they can significantly reduce the amount your beneficiaries receive. The federal estate tax is imposed by the IRS. As of 2024, the federal estate tax exemption is $12.92 million per individual. This means that if your estate is valued below this threshold, it will not be subject to federal estate taxes. For estates exceeding this amount, the tax rate can be as high as 40%. State estate taxes vary significantly from federal estate taxes. Several states impose their own estate taxes with different exemption limits and rates. For example, New York has an estate tax exemption of $6.58 million with a top tax rate of 16%, while California does not impose a state estate tax at all. It is essential to understand the specific laws in your state to effectively plan and minimize your estate tax liabilities. There are several strategies to minimize estate taxes. One common method is gifting. The IRS allows individuals to gift up to $17,000 per person per year without incurring gift tax. By gifting assets to your heirs while you are still alive, you can reduce the overall value of your estate. Charitable donations are another effective strategy. Donations to qualified charities are deductible from your estate, reducing the taxable amount. Establishing charitable trusts, such as a charitable remainder trust or charitable lead trust, can provide you with income during your lifetime and reduce estate taxes. Trusts are also valuable tools for managing and reducing estate taxes. Irrevocable trusts, for example, remove assets from your estate, thus lowering the estate's value and potential tax liability. Special needs trusts can ensure that beneficiaries with special needs are provided for without disqualifying them from government benefits. Life insurance can be a useful tool in estate planning as well. By setting up an irrevocable life insurance trust, the proceeds from your life insurance policy can be excluded from your taxable estate, providing liquidity to pay estate taxes without depleting other assets. Family limited partnerships allow you to transfer assets to family members at a discounted value, reducing the overall value of your estate and providing tax benefits. Let's look at some real-life examples. The Smith family, with an estate valued at $20 million, reduced their estate by $1.7 million over 10 years by gifting $17,000 annually to each of their 3 children and 7 grandchildren, significantly lowering their estate tax liability. In summary, understanding estate taxes and implementing effective strategies can significantly reduce the tax burden on your estate. Whether through gifting, charitable donations, trusts, life insurance, or family limited partnerships, there are numerous ways to minimize estate taxes and preserve your wealth for future generations. If you need assistance with estate planning, consider consulting with an experienced estate tax attorney. They can provide personalized advice and strategies to meet your specific needs. Thank you for watching. If you found this video helpful, please subscribe to our channel for more informative content on estate planning and related topics. In this video, we will explore the responsibilities associated with a power of attorney and what you need to know as an agent or principal. A power of attorney, or POA, is a legal document that allows one person, known as the agent, to act on behalf of another person, called the principal. This authority can cover various aspects of the principal's life, depending on the type of POA granted. There are several types of power of attorney, each serving different purposes. A general power of attorney grants broad authority to handle financial and legal matters. The special or limited power of attorney restricts the agent's authority to specific tasks or situations. A durable power of attorney remains effective even if the principal becomes incapacitated, ensuring continuous management. A springing power of attorney becomes effective only under specific conditions, such as the principal's incapacitation. A financial power of attorney specifically grants the agent authority to manage financial matters, including banking, investments, and real estate transactions. And finally, a healthcare power of attorney allows the agent to make medical decisions on the principal's behalf. As an agent, you have several key responsibilities. You must always act in the principal's best interest, making decisions that align with their preferences and well-being. Managing finances is another crucial duty, which includes paying bills, managing investments, handling taxes, and budgeting. Keeping accurate records of all transactions and decisions made on behalf of the principal is essential. These records ensure transparency and accountability. If you have the authority to make healthcare decisions, you must choose healthcare providers, consent to treatments, and access medical records as needed. Agents must act within the scope of authority granted by the POA document. Any actions taken beyond this scope can be invalid. As an agent, you have a fiduciary responsibility to avoid conflicts of interest and refrain from benefiting personally from your role. You are also accountable for any misuse or mismanagement of the principal's assets. A power of attorney can end in several ways. The principal can revoke the POA at any time if they are mentally competent. The POA automatically ends upon the principal's death, with responsibility passing to the executor of the estate. Additionally, a court can terminate a POA if the agent is not acting in the principal's best interest. Understanding the principal's wishes is crucial, so regular and open communication is necessary. Staying organized with calendars, technology, and regular reviews of the principal's assets is vital. Seek professional advice when facing complex situations and handle conflicts diplomatically while documenting your decisions meticulously. The phrase "life is